That's all, that's all. See, all that we want is, why don't you just pass on adjudicated? We will not go for it. We cannot do it. Make a claim before
Because the lab red is has not been functional. The NFIC should discharge the functions and
Okay, June 2022. June 2022.
circular.
Circular.
Circular hard.
Okay.
Hard one very scheme not like particular.
So,
Hard one.
in person to para 4 of the scheme, as amended by penalty, as amended by caseless penalty amendment scheme in suppression of the order. Right. Okay.
ಕಾಣಿಸ್ತಾ ಇದಾರೆ, ನನಗೂ ಹೊಸದಾಗಿ ಕಾಣಿಸ್ತಾ ಇದ್ದಾರೆ. ಕಾಣಿಸ್ತಿಲ್ಲ. ಇವು ಬರ್ತದೆ.
Yes. Come. Serial number 40. Yes. Please touch it. Call this matter week after next. Finally, on the request of arguing counsel's ill health.
My lords, can I request for 3rd February, my lords?
ಡೇಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಡಿಫಿಕಲ್ಟ್ ಇದೆ. ಯಾಕಂದ್ರೆ ಬೇರೆ 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 ಕಾಂಬಿನೇಷನ್ ಎಲ್ಲ ಇರೋದಕ್ಕೆ ಡಿಫಿಕಲ್ಟ್ ಇದೆ. ನೋಡೋಣ ಅವು ಬಂದಾಗ. ಓಕೆ,
Obliged.
Obliged.
I was moving a matter, my lords, the penalty matter, my lords, the penalty matter, my lords. I'm moving the other matter, my lords.
ನೋಡಿ, ಅದು ಎದ್ರ ಜೊತೆ ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ ಎದ್ರ ಜೊತೆ ಮಾಡ್ಬೇಕು?
It's already
Adil.
271D, which is the triggering, which is the initiation point.
ದಟ್
I want to place.
ಪೆನಲ್ಟಿ
arguments.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ 271D.
ಹೌದು, ಅದು ರಿಸರ್ವ್ಡ್ ಆಗಿದೆ.
ಕರೆಕ್ಟ್. ಆಯ್ತು.
ಅಂದ್ರೆ this honorable court expressed a view that they will examine the whole issue with regard to the
ಬಿಕಾಸ್ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್
undue delay and latches.
Correct.
ಇದ್ರಲ್ಲಿ ಅದು ಇಲ್ಲ.
ಅಲ್ಲ ಇರ್ಲಿ, ಅದು ಬರ್ಲಿ. ಬಿಕಾಸ್ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್, ಕೇರಳ
High Court, my
ಹೈಕೋರ್ಟ್,
Kerala.
ತೆಲಂಗಾಣ ಹೈಕೋರ್ಟ್ ಇದೆ. ಕೇರಳ ಹೈಕೋರ್ಟ್ held in your favor.
Yes.
Delhi High Court to some extent held in favor of the assessee. I examined that actually. ಅದಕ್ಕೆ ನೋಡೋಣ, ನೋಡ್ಕೊಂಡು ಮಾಡೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ.
Next one.
ಓಕೆ.
Next one.
My lord, serial number 41,
ಹಾ,
the counsel for the appellant is unwell, my lord.
41.
41, Mr. Jeevan Niralgi.
Niralgi is not well.
Please,
Why, what happened to him?
he's on,
Right.
that's what happened.
Panel counsel appearing for the revenue stated to be not well. First, call after 2 weeks.
Please,
Even health ground ಇರ್ಲಿದ್ರು ನಾವು ಟೈಮ್ ಕೊಡ್ತೇವೆ. ನೀವೇನು ಇಲ್ಲಿ ಹೆಲ್ತ್ ಅನ್ನೆಸೆಸರ್ಲಿ you need not
I
ascribe.
informed that he's unwell, so I.
Very.
But serial number 38, I appear for respondent 38, my lord. I have informed the appellant counsel.
ಇಲ್ಲಿ ಬರ್ಬೇಡ ಅಂತ ಹೇಳ್ಬಿಟ್ರ ಅವ್ರಿಗೆ.
ಇಲ್ಲ short accommodation. Idರಲ್ಲಿ this file has renominated to me. I have collected the file. I'll just get ready.
2 weeks.
2 weeks or 1 week. Either don't
Call after 2 weeks. At the request of.
Serial number 36, please. 36. Serial number 36, please, madam.
36.
36, I'm for a response.
2017.
Yes, madam.
If Aditya agrees, so I can give, otherwise no.
maybe next week or week after.
Alright, week after next, at the request of so and so. First off, this adjournment is granted reluctantly. Okay.
For order seal number 1, Keshav Bhatt,
Keshav Bhatt.
TP
Here is-
Muttana,
My lord,
Second set you file ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಮತ್ ಮಾಡ್ಬೇಕು ಅದನ್ನೆಲ್ಲ.
ಅದು
ಕೋರ್ಟ್ ಬೇರೆ ಯಾರು ಮೂವ್ ಮಾಡಿದಾರೆ ಇದನ್ನ? Who has moved the court?
petitioner,
Petitioner. Second set ಯಾರು ಫೈಲ್ ಮಾಡ್ಬೇಕು?
second set ನಾವು
ನೀವು ಅಂದ್ರೆ ಯಾರು ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
respondent.
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 Bank.
Two sets. ಇವತ್ತು ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
Copies. Office objection to be complied with by the respondent forthwith. Call next week.
I prefer respondent number 2, my lords.
You are for a second respondent too.
Yes, my lords. The successful bidder.
All. Interim order to continue till next date of hearing.
Much.
Seal number 2, Shivaramu.
Compliant, your lordship.
Anything.
My lord was pleased to dispose of the matter, my lord, on 27th October 2023, my lord.
Delay application ಹಾಕೋದ್ ಬೇಡವಾ?
ಅದೊಂದು ಹಾಕ್ಬೇಕಾಯ್ತು.
ಹಾಕಿ.
I am sorry, my lord.
ಹಾ.
Monday I will.
Post after delay, office objections are complied with.
Gratefully, lordship. I'm sorry for the inconvenience.
ಅದೊಂದು ಎಕ್ಸಾಮಿನ್ ಮಾಡಬೇಕು. Under section 20,
Yes.
Contempt of Courts Act ಕೆಳಗಡೆ,
Yes,
whether delay can be condoned,
yes,
whether section 5 of the Limitation Act can be invoked. You have to examine that also.
yes, sir.
Huh?
Yes, sir.
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಣಲಿಲ್ಲ ಅದ್ರ ಮೇಲೆ. ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Seal number 3, Dilip M.
ದಿಲೀಪ್ ಏನಿದೆ?
Permitted to take notice for the respondent.
ತನ್ಮಯಿ,
Yes, ma'am.
Madam Tanmay appears for respondent SSC. ಅವ್ರಿಗೆ ಕಾಪೀಸ್ ಎಲ್ಲ
What is
ಕೊಟ್ಟಿದ್ದೀವಿ.
it? We have served.
Objection ಏನದು? On presentation form dated 3/9/2024.
That doesn't survive.
All right. Objection overruled.
Seal number 4, Government Advocate, Tanmay Rajkumar.
In this matter, the question involved is, my lord.
Why AG is coming in tax matters? Yes, Shashi.
My lord, the implication on the point of law is, my lord, what the learned single judge says, once moratorium is order is there, my lord. The question, the Supreme Court has said there's no recovery. The question of adjudication can go on, my lord. We are saying that let the adjudication go on, recovery cannot be done. In covered by Supreme Court judgment on the identical facts, my lord.
Adjudication for what purpose?
For assessment of liability, my lord.
Liability.
Liability, that's all, my lord. Your lordship may say that we will not initiate recovery.
That cannot be done. Supreme Court says nothing during the moratorium period, nothing can be done. Lord, see section 14 of the IBC. In any case, let them explain the delay. There's a 433-day delay.
ಒಂದು delay application ಹಾಕ್ಬಿಡಿ.
Condone,
Huh?
we have filed a delay.
That's not condoned. We have
The
filed
application
objection.
ಫೈಲ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋಣ.
433 days delay.
Up to
1.5
500 days now.
one year, 3 months, the officer says
My
he's
lord,
been reading the file.
Rather
Kindly see
than-
para 3 and 4.
Instead of two,
They work that way. Otherwise, where was the occasion for you to be here?
No, that's exactly, my lord. Supreme Court now is heavily coming down on revenue in
Yeah.
not filing
In fact,
appeals. More than 100 days delay is
in
not
fact,
being
the
condoned.
steps,
The
even
detailed orders.
even I have
part.
taken steps to see that all government orders are implemented.
We have considered that judgment. 8th of January, perhaps, 8th or 9th of January. We have considered it yesterday.
Here, if my lords kindly see the application for delay, paragraph 4, the officer says for 1 year, 3 months, he's been reading the file.
That's how.
And just this thing, that's one thing.
Surya Deva can argue on merits always, not these
No.
small things.
That is one, that I will leave it to your lordships. I am only saying that we have filed objections, 433-day delay, not properly explained. As far as merits is concerned.
ಅದ್ ನೋಡೋಣ, ಮೊದಲೇ ಡಿಲೇ ಒಂದು ಚೇಂಜ್
ಹಾ.
ಮಾಡ್ಕೊಳ್ಳೋಣ.
Very good.
ಬರ್ಕೊಳ್ಳಿ. Appeal is filed after brooking a delay of 433 days. First, an application supported by affidavit seeking its condonation is also filed. First, objections are registered to the said application by the assessee. First, learned senior advocate appearing for the assessee vehemently opposes condonation of delay on the ground that an officer cannot be expected to say that he was reading the file for such a long period. And that delay in the case of official challenges cannot be leniently viewed. First. Next, having heard the learned Advocate General for the state and the learned senior advocate appearing for the assessee, we are of a considered opinion that the application needs to be allowed and delay accordingly has to be condoned. First, next paragraph. It hardly needs to be stated that matters much older than this have been languishing in the court cupboards, and that is one of the factors in considering the prayer for condonation of delay. First, after all, condonation of delay would not result into addition of merit to the challenge to the disadvantage of the other side. First, Mr. Advocate General, you have to present some books to the library. Yeah,
please.
which books you will?
Just discuss, Manoj.
Ah.
The authority, the officers have written 2 books on GST, Manoj. The officers have written. Can I?
Yes, that will be great. Your officer has,
Our
that
officer.
will be great actually.
Compilation of
Ah.
GST Act.
GST
Ah.
Act.
And the latest notification.
Perfect. In the above circumstances, application having been favored because of we finding the explanation offered for the delay being plausible, delay is condoned, subject to the condition that the appellant shall present a set of 2 books which compile the law relating to GST.
GST, please.
GST. To the advocates association library. Within 10 days.
10.
Within 10. Eh?
It is
Compared to one of the assistant commissioner.
Very well.
Shakir Khan.
Okay. But why can't you tell your officer not to take so much time to read such a small file?
ಅಲ್ಲ ಓದ್ಬಿಟ್ಟು ಅಲ್ಲ if you see ಓದ್ಬಿಟ್ಟು book ಬರ್ದಿದಾರ ಅಂತ.
If that is the case, he also will be very happy. Very well, ಸರಿ. ಯಾವಾಗ ಇಟ್ಕೊಳ್ಳೋಣ?
Any date convenient you lordship.
Which date you want, Mr. Surya?
Can it be on 28th?
Please.
28. Right.
Grateful to.
Okay.
Till number 5, Jairo.
Yes.
Appearing for the petitioners, my lords.
Ah.
LGC proceedings has been dismissed, my lords. We've already filed the withdrawal memo on 1st of July last year, my lords.
Huh?
My lords, the LGC.
One main matter itself has gone now.
Please, my lords.
Parkali. Learned counsel appearing for the petitioner submits that the prosecution proceedings at the hands of the special court under the other land grabbing, etc. Act so and so have ended in
It's been
dismissal.
dismissed, my lords.
Dismissal, and therefore the petition has become infructuous. First, ordered accordingly and petition is disposed. Alle on the response, you on the notice government.
HGA book.
Okay.
Chandini.
Yes, next.
6, government advocate.
Notice this, there's a delay in this matter and the section has not indicated the number of days. I'll have that compliance done, my lord.
All right. 2 weeks for compliance.
Previous matter, my lord, learned AG had appeared. That company is my client in private practice, not on tax, but on the company side. So I was disabled from appearing. I couldn't assist the AG.
Very well. No issue. Oh, that's the reason he came.
I couldn't assist him.
When Aditya is here, where was necessity for Shashi?
I couldn't
His
assist him.
son in Sanskrit.
No, that is
Shashi Chandra in Sanskrit. Is it not? Anyway.
Till number 7, Prashant VG.
My lords, I appear for the petitioner in the matter.
Yes, brother.
My lords, for R1 and R3 have left the addressee. It says addressee left in the Shara. I request that I may be permitted to serve the counsel in the trial court who represented the respondents.
Counsel na. The paper publication. First steps.
Your Honor, objections hakidare that haven't taken steps 3 times anta.
Yes. Counsel for the petitioner is permitted to take notice to the counsel representing the respondents. In which court?
Commercial court at Bangalore.
In the jurisdictional commercial court where proceedings are pending. First, the learned judge of this court shall facilitate service of notice on the respondents, respondents. Okay. This to be done immediately.
My lords, the proceedings are not pending.
They are not pending there.
No, my lords. We have
Then
filed a
it
writ
cannot
petition.
be done. Then recall that order. Fresh steps to the steps to be taken, appropriate steps to be taken for service. Okay.
My lords, a date may be given in the matter.
With date kodak baralla, service ಮಾಡಿ ಬರಬೇಕು. Service post immediately after service. Okay.
Number 8, KP Darshan.
In this, my lord, my son is respondent.
Lordship.
I'll undertake to file the wakalat on
Lordship,
behalf.
in two connected matters.
Along with
Lordship,
two connected
Lordship,
matters.
Learned Senior Counsel D.R. Shankar appeared. Your Lordship are pleased to grant an interim order of.
No, my lord.
This is.
One second, you don't permit, please take your seat. Please be seated. I will hear you. I will not pass any order without hearing you. Please be seated. Kindly be seated.
Wait, sir.
You will not sit. Okay.
Lordship,
Then we have to raise.
Lordship, on 7th January 2025, Your Lordship.
Huh.
Lordship was pleased to grant an interim order of stay on.
Identical matter?
Identical matter.
Tell
This is
Torsi.
related to JDA, where Learned Senior Counsel appeared, where landowners have filed a consumer complaint, Your Lordship.
Petition ಎಲ್ಲಿದೆ?
Lordship, that.
ಅಲ್ಲಿ ನಿಮ್ಮಲ್ಲಿದೆ.
That's connected matter. 7th it was listed, Your Lordship.
ಇದರಲ್ಲ. Identical matter ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೇವಾ?
Please, Your Lordship.
Very same matter ನಲ್ಲ?
Same matter, same relatives.
ಕೊಡಿ ಅವರಿಗೆ.
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ 12 years ಇಂದ ಪೊಸಿಷನ್ ಕೊಡ್ದಿರಾ ಆಟ ಆಡ್ತಿದ್ದಾರೆ ಇವ್ರು. I am a landlord.
You are the landlord.
Yes, my son is respondent in this. 12 years ಇಂದ ಆಟ ಆಡ್ತಿದ್ದಾರೆ. They have taken the courts for their granted. ಅವರು ಇವಾಗ ಸ್ಟೇಟ್ ಕಮಿಷನ್ ಅಲ್ಲಿ ಇವಾಗ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ. I'll file. No, I have not filed wakalat also. I am taking permission from this honorable.
Why you can appear? Your son is the party.
Yes,
Lordship,
respondent.
but generally-
My son is respondent.
Lordship, what has happened is, once the notice.
ಅವ್ರ ಜೊತೆ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ.
Sorry, sir.
ಯಾಕೆ ಇಷ್ಟು ಮ್ಯಾನರ್ಲೆಸ್ ಆಗಿದ್ದೇವೆ ನಾವೆಲ್ಲ ಅಲ್ವಾ? ಒಬ್ಬರ ಜೊತೆ ಮಾತಾಡುವಾಗ ನಡೆಯು ಭಯ ಹಾಕೋದು ಅವರಿಗೆ ಇನ್ಸಲ್ಟ್ ಮಾಡ್ದಂಗೆ ಅಲ್ವಾ?
No, Lordship, apologies to my counsel.
ಇದು ಅಪ್ಲೈಸ್ ಟು ಎವ್ರಿಬಡಿ, ಟು ಅಸ್ ಆಲ್ಸೋ. ನೀವು ಏನೋ ಒಂದು ಹೇಳ್ತಾ ಇದ್ದಾರಪ್ಪ, ಅಷ್ಟು ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
ಸ್ಟೇಟ್ ಕಮಿಷನ್ ಅಲ್ಲಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಆಗಿದೆ. 12 years ಇಂದ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಫ್ಲಾಟ್ಸ್.
ಡೋಂಟ್ ರಿಪೀಟ್, ಯು ಹ್ಯಾವ್ ಸೆಡ್ ದಟ್. ಹೊಸದು ಹೇಳಿ. ಈಗ ಹೇಳಾಯ್ತು ನೀ ಅದನ್ನ.
ಅಲ್ಲ,
ಎಷ್ಟು ಸರಿ ಹೇಳ್ತೀರಿ?
5 crores ಅವಾರ್ಡ್ ಆಗಿದೆ. ಅದನ್ನ ಕೊಡಕ್ಕೆ ಇವಾಗ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ತಪ್ಪಿಸ್ಕೊಳಕ್ಕೋಸ್ಕರ ಇವ್ರು ಇದನ್ನ
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ
ಆಗ್ತೀನಿ, ಟೈಮ್ ಕೊಡಿ, ಬಟ್ ಸ್ಟೇ ಕೊಡ್ಬೇಡಿ.
ಹಂಗೆ ಹೇಳಕ್
ಬೇಡ, ಅರೆಸ್ಟ್ ಆಗ್ಬಾರ್ದು ಅಂತ ಇವ್ರು ತುಂಬಾದ್ರಲ್ಲಿ ಆಟ ಆಡಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲೂ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ.
ಅಲಾಂಗ್ ವಿತ್
ಅಲ್ಲಿವರೆಗೆ ಅರೆಸ್ಟ್ ಮಾಡಬೇಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ.
ಆಯ್ತು.
ಅದು ಇದು ಇರಲಿಲ್ಲ ಅಂತಂದ್ರೆ ವಿಲ್ ಟೇಕ್ ಅಪ್ ದಟ್ ದಿಸ್ ಒನ್. ಯು ಡೋಂಟ್ ವಾಂಟ್ ಟು ಕಾಂಪ್ರಮೈಸ್.
There is no jurisdiction also. They have to approach for the National Consumer Forum. Even though they have.
Counsel appearing for the respondent makes only oral submissions. That is difficult to consider. First, call this matter next week.
Along with other matters.
In the meanwhile,
Connected matters.
you have not even filed wakalat.
I'll file my
Notice.
lord.
Notice.
No, wakalat ಹಾಕಿಲ್ಲ. ನಂತರ KVA ಇಲ್ಲ.
ಈಗ ಬರೋವಾಗ ನೋಡ್ಬಿಟ್ಟು ಬಂದೆ.
ನೋಡ್ಕೊಂಡು ಹಂಗಿದ್ರೆ ಹೋಟ್ಲ್ ಅಲ್ಲ ಇದು, ಕಾಫಿ ಹೌಸ್.
Sorry, my lord.
ಒಂದು KVA ಹಾಕೋಬೇಕು, ಏನಾರ ಒಂದ್ ಬೇಕಲ್ಲ ಒಂದು.
ಆಗ್ತೀನಿ ಸ್ವಾಮಿ.
ಮತ್ತೇನು ಮಾತಾಡ್ಕೊತ ಹೋದ್ರಿಗೆ? Please be seated. You don't have right to audience at all. ಬರ್ಕೊಳ್ಳಿ. Issue emergent notice, interim order as prayed for till next date of hearing. Call these matters along with.
It may be posted for next week, my
You
lord.
have no audience because you are nowhere, you have not even entered KVA. ಆ ರೀತಿ ಹೇಳಿಕ್ ಬರ್ತದ? ಮತ್ತೆ KVA ಅದಕ್ಕೆ ಇರೋದು. ನೀವು ನೋಟಿಸ್ ತೊಗೊಳದಿದ್ರೆ ಬರೀತೀನಿ, ನಿಮ್ಮ ಹೆಸರು ಬರೆಯೋಣ.
ತಗೋತೀನಿ sir.
ಶ್ರೀಮತಿ so and so
IPV.
appears for which respondent?
Sole respondent.
Only one respondent.
Respondent. With leave of the court. With leave of the court. Since the said respondent happens to be her son, correct? Okay. Second respondent not made party.
Because the managing director, the company has preferred this writ petition. Respondent number 2 need not be made a party in this proceedings.
Office objection for the time being is kept under suspended animation. Okay. When do you want?
Next week, my lord.
Call this matter. ಒಂದಾದ್ರೂ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಮತ್ತೆ ಬರಲ್ಲ.
Along with the writ petitions.
ಆ ಡೇಟಿಗೆ ರೆಡಿ ಇರಬೇಕು.
Please.
Otherwise, go for compromise. You can't go on harassing people. Call these matters along with so and so on ಒಂದು 10 ದಿವಸ ಟೈಮ್ ಕೊಡಿ. ಅದು ನೆಕ್ಸ್ಟ್
Achha.
Number 9. Mahesh Chaudhary.
That's, I appear for the petitioner in this matter.
Yes, Mr. Chaudhary.
The matter arises out of a proceeding pending before the arbitration tribunal. On the ground that the mandate is over, and I'm also seeking for substitution of the arbitrator before this court.
Is it?
And the reason being, and before that, there are two clerical office objection, where translation is required and typed copy is required, Translation may not be required before this court.
Translation dispensed it.
And so far as
Other
the
typed copy legible
typed copy,
idea?
I'm not going to rely upon, which is at page number 27.
Page 7. All right. Filing of typographed copies of subject and annexure is also dispensed with.
Grateful, now, I am not seeking for a stay of the proceedings.
Issue emergent notice.
Emergent notice, I may be permitted to take notice on.
In addition to taking usual steps, the petitioner is permitted to serve a copy of the petition on the counsel who represents the respondent before the erstwhile arbitrator.
Yes, that's one request. I'm not seeking the stay of the arbitration proceedings.
You said it twice now.
Yes, I'm sorry. The interim prayer, so far as the respondent not alienating the subject matter, may be
That is
considered.
property.
Property, it's a dispute arising between a landlord and a builder, whereby the landlord is trying to alienate the properties, which was also the subject matter, and the arbitrator did not consider
The
it.
subject property shall not be alienated or encumbered till next date of hearing.
Grateful,
Okay.
That's anytime next week or week after.
It will come, it's, I think.
Once
Entry
we start-
ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ argument ಮಾಡಿದ್ರೆ vacate ಮಾಡಕ್ಕಾಗ್ತದೆ ಅಷ್ಟೇ. Don't waste time. Yes.
Hearing on yes, number 10, Dilip M.
Lord, 122 days delay.
Application ಕೊಟ್ಟಿರ ಅವ್ರಿಗೆ? ಕೊಟ್ಟಿದ್ದಾರೆ. Appeal is filed after booking a delay of 122 days. First, application supported by affidavit is moved seeking condonation of the same. First, condonation is, the application is opposed by the learned counsel appearing for the assessee. First, next, having heard the learned counsel for the parties and having perused the case papers, we are of the considered opinion that there is a plausible explanation offered for the delay brooked, and therefore delay needs to be condoned. First, ordered accordingly, and IA is disposed of. Yes.
Number 11, Vinay Chanmati.
Sanmati, 19 days ಇದೆ. Notice ಆಗ್ಬೇಕೇನು?
Tanmay.
We'll condone that.
Yes.
Appeal is filed after booking a short delay of 19 days. And explanation, plausible explanation is offered for the same. First up. In view of the above, application is favored and delay is condoned. Next.
Number 12, Lokesh Munish Batra, be promoted.
That's I
Accused in this matter, sir.
complainant in this matter.
Request for a short accommodation. USG is appearing in the matter. He is not there in town, my lords.
Kodboda, Dhanlakshmi,
Other than.
call after 2 weeks at the request of. Yes.
Number 13, government advocate.
There is a delay in this matter.
Notice ಹೋಗ್ಬೇಕಾಗತ್ತಾ no?
My lords.
Issue emergent notice.
13, government advocate.
Same, my lords.
Same order.
Right.
Number 15, Arvind V. Chavan.
There is a delay of 14 days. Notice.
Emergent notice.
Number 16, Tushal Tiwari.
There's a delay, my lords, for 109. This other side has been served, my lords, if not entered appearance.
I'll file my,
Appear.
I'll file my.
Madam Tanmay appears for respondent SAC. First up. Anurama, application allowed on the, ಇದೆಯಲ್ಲ ಆ ರೀತಿ ಮಾಡಕ್ plausible. Delay condoned. Next.
Number 17,
17 also I'll file my.
Anurama, same order. Madam Tanmay appears, so delay condoned. Okay.
number 18, YV Raviraj.
Lord, 168 days delay.
Emergent.
Notices. please.
Emergent notice.
Number 19, Kavita D.
Pass over. All right. You appear for respondent. Pass over.
Number 20, parting person, Ashok Kriplani.
My lordship, in this case, I have sought some amendment, small amendment. I filed the application.
My lord, short pass on, my lord, senior is.
Pass over.
Yes.
All right. Pass over.
Number 21, Arvind Vishnu.
My lord, there is a delay of 50 days. Notice has to.
Notice of a
Yes.
22, preliminary matters, EI Sanmati.
Yes, sir, appellate court. Your lordship, I may be permitted to take out notice in identical cases. This honorable court has
We have
issued
done that,
notices.
Issue emergent notice. First, call this matter along with. All right.
23, Prasanna Kumar.
I represent my lords the petitioners counsel.
Ah.
But I challenge my lords the impugned order where the trial court my lords had.
Are you ready in the matter?
Please.
Padi. You are friend.
Notice.
Fresh matter has to go.
Fresh matter. Preliminary.
I thought. Then full bench judgment cover agata nidu.
How's Arjun Pandit
Issue
judgment
emergent notice.
may also be permitted to my lord serve on the council representing the.
In addition to taking usual steps, the appellant, the petitioner to shall serve a copy of the petition on the learned counsel representing the accused before the special court.
Please.
Before the special court.
Please.
Number 24, K.R. Krishnamurthy.
Krishnamurthy.
For the respondent.
Yenidu Krishnamurthy.
For respondent. 24, K.R. Krishnamurthy.
Pass over.
25, EI Sanmati.
This is the transfer pricing case from Supreme Court remand matter.
Sorry, welcome. Appeal is admitted on the following substantial questions of law. We have also noted that a few of such questions are being debated before a coordinate bench of this court. Okay. Yes.
26, Dilip M.
Dilip.
By Rajkumar.
But the issue is covered against the revenue. My lord, revenue filed this appeal, my lord, challenging the order of the tribunal, which my lord, which held that the order passed by the transfer pricing officer is beyond the limitation. So that is decided now, my lord.
Nothing is identical matter on the other one judgment ಬರ್ದಿದ್ವಿ ನಾವು ಯಾವ್ದು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಫಾಲೋ ಮಾಡಿತ್ತು ನಾವು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ತಿದ್ವಿ
Tata Power Solar Systems.
The subject matter of this appeal is substantially similar to the one treated
12th August 24.
in ITA number 527 and 528 of 2022 between Principal Commissioner of Income Tax versus Tata Power Solar Systems Limited, disposed of by a coordinate bench of this court on 12/8/2024. First off, in view of the above, this appeal is dismissed madbaka? Dismissed. Is liable to be and accordingly dismissed. Courts having been made easy. Okay.
Lord's question of law will be answered against the revenue.
Answered against them. But anyway, we're saying that covered by inter. Okay. Next.
Number 27, EI Sanmati, Tanmay Rajkumar.
Lordship, in this case, the tribunal has followed its earlier order of this honorable court for earlier assessment years, my lord. The revenue had filed SLPs before the honorable Supreme Court against the orders, my lord. It has been dismissed.
Yes. Then nothing remains here. This is liable to be again dismissed only. Kodi.
Supreme Court also dismissed the SLPs.
The subject matter of this appeal is substantially similar to the one in ITA number
294, 827 and 829 of 2018.
ITA number.
294, 827 and 829. Reported in 2023, 150.
Substantially covered by the judgment of coordinate bench of this court.
It's an SC's own case, fully covered. SC's own order.
SSC's order only.
In the SC's own
In-
case, this
In
judgment,
2023, 152, taxman.com 102 Karnataka between. So in,
the very same.
Apple India Private Limited versus Deputy Commissioner of Income Tax. First up, in the said case, incidentally, the very same assessee was the appellant. First up, in next paragraph. In view of the above, full stop, next paragraph. We are also told at the bar that challenge to coordinate bench decision has been negatived by the apex court in SLP civil diary number 5282 of 2024, disposed of on 7/3/2024, correct?
That's right.
3/2024. First up, in view of the above, the appeal is dismissed. First having been made easy. That our ಹೆಸರು ತೋರಿಸ್ಬೇಕಾ senior advocate.
Number 28, Mohammed Monish Sombar.
Lord, I'm appearing for petitioner in this matter, my lord. The question of substantial question of law is raised in base number.
Then substantial question of law, no? Question of law, no?
Question on.
Only question of law.
Office doesn't appear to have been served. If my learned friend serves me, I'll.
Copy kodi. Fresh matter. Issue
I'll maybe
notice.
permitted to take notice.
Issue
And
notice.
Even
Sri
tomorrow.
Aditya, learned AGA on request accepts notice for the revenue.
Because the admission is after hearing parties. So even tomorrow, my lords, if my learned friend is okay, I can.
This is a very strange provision. In fact, converse of other regular provisions. No, it's not substantial question of law. It's only question of law.
My lords.
All right, next week. Okay. Next week, call next week. Identical question we treated in one matter, whether it is question of law or substantial question of law. You appeared in that matter? You have not appeared.
Sure.
Okay.
Your lordships may have seen it and where Mr. Naganand was arguing under 10F of the Companies Act, it is mere question of law.
Correct.
Correct. No substantial question of law.
Correct. Not a substantial question. What is difference between question of law and substantial question of?
I had read the point. I'll refresh my memory and make myself.
In fact, in Salmon's jurisprudence and in Patent's jurisprudence, two books very beautifully discussed what is a question of law, what is a question of fact. In fact, Salmon classifies, of course, Julius Stone also, Law and Lawyer's Reasoning, one of the famous books. He says, all questions that arise before a court of law are of four types. One is question of fact, whether Alexander had come to India in BC 323. Evidence can be led and can be shown. Yes, Alexander had come with the army. So question of fact. Question of fact means any fact for proving which evidence is permissible. Leading of evidence. Of course, there is one exception where evidence was permitted to be led to prove Magna Carta is law in English court. Because Section 5 of our Evidence Act says evidence can be led to prove fact in issue or facts relevant to the facts in issue and nothing else. But that's an exception. African court also permitted Attorney General of some state to lead evidence to show that particular instrument was an instrument of law. The first one is facts. The second one is questions of law. Someone shows it very beautifully. Any question answer to which has to be found by turning the pages of the statute book is a question of law. Then question of discretion, whether 5 years imprisonment, 3 years imprisonment. Then the last one is question of opinion, whether a person like Alexander again will come in 2029 to this country. It's an opinion. Whether Tata fact the oil mill shares will jump to the sky is an opinion, question of opinion. That way, very beautifully they have discussed. So those who argue on question of law, substantial question of law, they should do this. There's one best article written by Justice Ananda Bhaira Reddy of this court. What is substantial question of law in appeal? It was published in SEC. I don't remember the year, but very good article. Just look into, because that question will arise even in your matter. Identical question is there. We have held in Dharwad. Substantial question of law under your act is akin to the substantial question of law under section 100 of CPC, section 30 of Employees Compensation Act. So several acts. That way we have held. The one, perhaps you argued that matter. Correct. Yes. ಇಷ್ಟೆಲ್ಲ ಯಾಕೆ ಹೇಳ್ತಾರೆ ಅಂತ ಕೇಳ್ಬೇಡಿ. ಬಹಳ ಜನ ಇಂಟರ್ನ್ಸ್ ಇರ್ತಾರೆ, ಯಂಗ್ಸ್ಟರ್ಸ್ ಇರ್ತಾರೆ. ಅದಕ್ಕೆ ನಾವು ರಿಫ್ರೆಶ್ ಮಾಡ್ಕೋಬೇಕಲ್ಲ. ಅದಕ್ಕೆ
Samant is a very accessible book for the interns because being concise.
Correct. Best book. Samant. Pattern is also very good. Jurisprudence. Mahajan, VD Mahajan has written Jurisprudence of India. It's a different book. Jurisprudence and Legal Theory by VD Mahajan. One of the books, one of the good books which I felt. Yes. ಪುಸ್ತಕ ಎಲ್ಲ ಓದ್ಬೇಕು, ಓದ್ತಾ ಇರ್ಬೇಕು. ಹೆಂಗೆ ಹೊಟ್ಟೆಗೆ ನಾವು ಫುಡ್ ಹಾಕ್ತೇವಲ್ಲ, ಹಂಗೆ ಇದಕ್ಕೂ ಸಹಿತ ಫುಡ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತದೆ ಮಧ್ವ ವಿಜಯದಲ್ಲಿ. ಇದನ್ನೆಲ್ಲ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ಮಧ್ವಾಚಾರ್ಯರು. ನಿಜ ಅದು, ಅದರ್ವೈಸ್ ಕೆಟ್ಟ ಹೋಗ್ಬಿಡ್ತದೆ. ಇಫ್ ಯು ಡು ನಾಟ್ ಪುಟ್ ದಿ ಮಷೀನ್ ಟು ಯೂಸ್, ರಸ್ಟಿಂಗ್ ಟೇಕ್ಸ್ ಪ್ಲೇಸ್. 98 Supreme Court noted. PUCL versus so and so, so and so. Yes.
You want 29, Anand N?
Wait, please.
ಏನಿದು ಆನಂದ್?
Well, this is an appeal filed under section 35G of the Central Excise Act, challenging the order passed by the learned Sestat at Annexure K, and a substantial question of law which arises from the order passed by the learned Sestat. We have framed it at page number 10. My lords would get the substantial questions of law.
We read this book, this paper book. Why so lengthy?
Because
should not be that lengthy, because ನಾವು ಬರೀ ಇದನ್ನ ಒಂದೇ ಓದಕೋದು ಕೊಡೋಕ್ಕಾಗ್ತದೆ, ಹಂಗಿರಲ್ಲ. ತುಂಬಾ ಇರ್ತದೆ ವರ್ಕ್. ಅದನ್ನ ಸಕ್ಸೆಂಟ್ಲಿ ಇದರಲ್ಲಿ 1/4 ಸಾಕು. I have read this paper twice. It should not be that lengthy.
Because this involves a lot of factual based involves.
ಯಾರು ಸಹಿತ ಇಷ್ಟು ಲೆಂದಿ ಮಾಡಬಾರ್ದು. We know one of the allegations of Sir Ivor Jennings on India's constitution. It is verbose, prolific and rigid. Since constitution was very long, Ivor Jennings said this when he came for a lecture on constitutional Indian constitution in Madras. Instead of praising us, he said it is verbose, prolific and rigid. He said that way.
What happens, my lords, in
emergent
tax
notice.
laws?
Notice, sorry.
Okay.
Emergent notice. Must lengthy ಮಾಡ್ಬಾರ್ದು.
Alternatively, with the leave of my lords, can I serve it on the panel council?
Yes, issue notice. In addition to taking usual steps, the council for the appellant is permitted to serve copy of the appeal memo on the panel council. Panel council appearing for the revenue. Yes.
Number 30, yes, Sanmati?
For appellant note.
Ankur Pai?
This is also covered matter, not against revenue.
Against you, which is that?
Your lordship's judgment in.
Namde ಇದೆ ಅದು.
Nimde ಇದೆ.
The subject matter of this appeal is substantially similar to the one. We followed another judgment.
Yes, my lord. In this case, Vodafone.
Nodama, same order. Okay, corresponding changes ಮಾಡಬೇಕು. Okay. Vodafone. Okay.
31, YB Raviraj?
Lord, transfer
Yes,
pricing
Ravi.
matter, my lord. Substantial question of law in page number 9.
This appeal is admitted on the following substantial question of law. First, or ಕೆಳಗಡೆ?
3 questions.
Some of these questions are being debated. ನಮ್ಮಲ್ಲಿ ಇದೇನೋ?
It-
2 of these questions are being debated in that matter. Some of these questions are being debated in a matter in which there is ongoing hearing. Okay. Notice.
32. IV Raviraj.
32.
My lord, this matter, there was a search conducted in the name of the respondent, and certain incriminating materials came to be seized. And subsequently, my lord, the respondent made an admission on several occasions, my lord, on the issues of receiving, my lord, unaccounted cash for sale of buildings. He is a builder essentially, and also making expenditure, my lord, which are not found in the books. So addition came to be made.
Show
Yeah.
his admission.
My lord, yeah, on the first issue, my lord, page number 83, 84.
83.
Yes,
Which paragraph?
my lord, para 8.2.
Confronted with the material.
Then, my lord, he gives a finding in the next page.
He has confirmed the correctness of the statement.
Please.
Notice third. Okay. Emergent notice.
33. IV Raviraj.
This is also, my lord, transfer pricing.
ನೋಡಮ್ಮ ಹಿಂದಿನ ಆರ್ಡರ್ ಇತ್ತಲ್ಲ. Following substantial question of
Page number 9.
same page 9.
Yeah.
Yes.
Other hearing.
Sorry, my lord, page number 7. my lord.
ನೋಡ್ಕೊಳ್ಳಿ ಅದು ಕ್ವಶನ್ ಆಫ್ ಲಾ ಏನಿದೆ ಸಬ್ಸ್ಟೆನ್ಷಿಯಲ್ ಕ್ವಶನ್. ಓಕೆ. ಹಾ. ಎಸ್
Further hearing, number 34. Arun VM.
Passover. LCR required. Registry to call for LCR immediately. Post this matter next week. Interim order to continue till then.
Number 35. Madhukar M. Deshpande.
My lord, I seek for a 2 days accommodation, my lord. I am unable to do the research.
Check ಮಾಡ್ಕೊಂಬರ್ಲಿ.
Any date?
Larger issues, of course, we'll give that date. Both you argued otherwise. He also argued very, he was not perturbed by a volley of questions which you had put.
Lord, in fact, my lord,
Let
last
us-
application, this honorable court said.
But I could
Yes,
not,
ma'am.
look, in a chitti on contract,
Yes.
there is slight reference. Question is, where there is variation of terms of contract.
Yes.
Whether surety is discharged fully or to the extent of variation is the question.
Yes.
You had produced the
Yes,
other
ma'am.
day
Yes, ma'am.
one judgment where Jinnah had argued
had-
the matter.
Yes.
To some extent, I throw light,
Yes,
but
ma'am.
not fully.
Yes.
Let us see.
Yes.
Call this matter
Any
on the other one date 20, other one Saturday. 25th ತಗೊಂಡ?
Yes, ma'am. My lord, interim order may be continued.
Saturday ತೊಂದ್ರೆ ಇದೇನೋ? Interim order to continue. Much. Yes. Just ಹಂಗೆ ಒಂದ್ಸರಿ Answers on Contract ಅಂತ ಇನ್ನೊಂದು ಬುಕ್ ಇದೆ, ಬಹಳ ಚೆನ್ನಾಗಿದೆ. AG Guest has edited it. It's one of the best books on law of contract. Like that Cheshire, Fifoot and Firmston. Perhaps Aditya has seen that, Cheshire's Law of Contract. It's a great author who wrote on private international law also. Just look into it.
For final hearing, number 37, Government Advocate.
Yes.
Matter deals with section 70 of the VAT Act.
State ಜಾಸ್ತಿ ಇದೆಯಾ?
But
Because
44
they have chosen to remain,
unrepresented.
can you send one more notice to them?
As your lordship.
Notice ಕಳಿಸ್ಬೇಕು.
As your lordship.
ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ
Paper publication ಆಗಿದೆ.
ಆಗಿದೆ.
Paper publication ಆಗಿದೆ.
ಮುಗಿದೋಯ್ತಲ್ಲ, ಏನ್ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ.
Because I had taken the liberty and had paper publication placed. Memo is also filed.
Service held sufficient.
My lords.
Yes, tell. Yes.
What
is the?
My investigation reveals. Your lordships may see my reassessment order at page 84.
84. You're right. So and so.
My investigation reveals that there are certain dealers, which your lordships may see in about the third paragraph. T&D Company, Umaid Sales Corporation, RK Trading Corporation, SLV Enterprises, Puja Trading Corporations. All of these persons are said to have supplied goods based on oral purchase orders.
Oral purchase orders.
Oral purchase orders.
But law does not mandate that purchase order should be in writing.
Does not.
It can be.
Does not. On the one hand, but it goes to feed the evidence of the genuineness of the transaction. The next point I find is the unreliability of, when I compare the input tax credit that is claimed by the assessee and the turnover of the selling dealer, I find that these are unreliable. Then, my lords, on page 86, I return the finding that the dealer has claimed having made huge payments to these dealers, but failed to substantiate the physical delivery and receipt of goods. Purchase invoices do not contain in them relevant description of goods such as weight details, size, thickness, and measurements mentioned in the usual manners of practice. The transactions are without weight slips, freight vouchers, and in many cases without vehicle details generally mentioned, and in many cases without vehicle number of two-wheelers, three-wheelers, auto transport, so and so.
RTO confirmed it.
RTO has confirmed it. Thereafter, my lords, the next paragraph, Department of Commercial Taxes, after thorough investigation, has established that the 5 dealers referred above are bill traders or missing dealers practicing the modus operandi of bill trading syndicate. As such, it became evident that the dealer had knowingly obtained the false tax invoice and claimed input tax credit on the basis of them without physically receiving the goods. As per section 70, so and so. My lords, may
burden is on him.
Burden is on the assessee, my lords. Your lordships may skip that paragraph for a minute. I will make my submission on the law. Incidentally, the business premise of RK Trading Corporation mentioned in the invoice is said to be at 6x4, first floor, Banki Nawab Street, so and so, so and so, so and so. Umaid and Umaid Sailing Corporation have the same address at 6x5 Banki Nawab Street, SP Cross. These addresses are located in very close vicinity of dealers' business premises. It is also seen that RK Trading Corporation dealer is not having business establishment at given address. Dealers' transaction with them are credit basis, as he had made payments toward those purchases checks. It is indicated that the dealer has the knowledge of the nature of activities of those dealers and operators who operate representing such Benami firms. So I also come to I go visit it. I find that there is no person there. And I find that all these addresses are in the immediate proximity. And all transactions are credit transactions. Over the page, my lord.
Yes. KVA tempter.
Yes. Then the only documents about goods were invoices which are prima facie incomplete, unreliable. Dealer admitted that the payments were made to and goods were received through certain representatives, but not by the suppliers themselves. As such, dealer failed to establish the genuineness of transactions. Then, my lords, what happens? The dealer was called upon to exercise the written admitting by him that I will identify these persons and bring them to your office if need be, and he then fails to do it. Then he, on page 88, I record that I have not filed any objections, and therefore I am,
but expressed his inability to bring them.
Yes.
He identified them, but you could have issued summons to them.
I could, my investigation, I have visited the site itself, my lords. Once the burden is on him, I have visited the site, and it is my view under 39(1) when I'm carrying out reassessment that the burden of proof is not satisfied. Now, if he wants to, after service of notice, discharge the burden of proof, it is his witness for him to bring, my lords.
You have powers of the civil court only.
I have powers. I have powers. But when my officer goes there and conducts an investigation and prima facie sees, I will back that investigation, my lord. My presumption then has to be dislodged by him. Thereafter, my lords, what happens is that the first appellate authority confirms my order. The
Tribunal reverses it.
Tribunal reverses it. I am on the point of the appreciation by the tribunal, my lord, how the tribunal appreciates the law on the point.
Where is that?
Your lordships may kindly see. Your lordships may kindly come to page 34. The appellant, in support of its claim of input tax for the transactions affected to the dealers in question of the above tax period, has produced both buyer and seller invoices which recite the commodity involved in the transaction. Further, dates and names of the buyer, dealer, and seller dealers are also recited in the said invoices. Appellant has also produced the copy of returns in VAT 100 balance sheet, IT returns, so and so, so and so. The documents stated above are borne out from the appeal records. We have given our anxious consideration to the materials placed on records in the law governing the subject. Undoubtedly, burden of proof is on the appellant dealer to prove that the transaction is genuine and bona fide, and factual aspect is to be gathered from the materials on record. Perusal above documents coupled with the payments made by the appellant registered selling dealers through checks prima facie establishes the transaction. He uses the expression prima facie. The appellant also got issued notice to respondent and banks through their counsel furnishing the check details to verify the payment made and whereabouts of the dealer. No doubt, under the statute, a burden of proof is on the appellant dealer who claims input tax credit to prove the transaction. However, burden of proof is not static, but shifts once the initial burden is discharged. In the present case on hand, the appellant has placed ample materials to establish the transaction is required under statute and the proposition of law and laid down by the Honorable High Court and Coordinate Bench of this tribunal. Document placed on record such as purchase so-and-so, 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 regarding pertains to relevant tax period coupled with the payments made through checks, seller necessary implication, satisfies the discharge of initial burden cast upon it by the statute.
Correct.
Your lordships may pause here for a minute, my lords. The other, he then deals with the vehicles. My lords, on page 36, about the middle of the page.
Correct.
It is further observed that orders of A and FA, the good vehicle numbers are billed related to two-wheelers, the three-wheelers and trans. Hence, there is no actual movement of goods. It is seen from the document placed on record that the vehicle number used for transportation of the goods and dealers are also mentioned. B register of vehicles from the RTO so and so. Hence, inference drawn by the respondents, there is no movement of goods due to the specification of vehicle in the context is not acceptable. My lords, what happens is that these are metal sheets, and he's giving me details of two-wheelers.
It cannot be on two-wheelers at all.
Cannot be. Metal sheets, my lord. But, my lords,
But
I am
quantum may depend on quantity of the
quantity may depend.
other may depend on.
Depend agate. My lords, but the appreciation of the law, since I am required to come before this honorable court on a question of law, the appreciation of the law saying that there is such a thing as an initial burden of proof, which somehow seems to shift to me, my lords, is what I am aggrieved by, because that is a completely erroneous interpretation of the law. If your lordships may kindly take section 70 of the VAT Act.
What is difference between burden of proof and onus of proof in law of evidence?
The under 101 to about 105, my lord, the
of Evidence Act.
Evidence Act, the obligation to prove a fact lies on
who asserts
it, and if he does not lead any evidence as to that fact, the fact remains unproved.
And he would fail to get the relief.
He fails to get the.
That is section 101.
Yes, ma'am.
Of evidence.
Yes, ma'am. Yes, ma'am.
Onus?
Onus is capable of shifting, my lord.
That's what I also read.
Yes.
In Amirali and Woodruff. That between the difference between burden and onus is shifting one. That's how he writes, but I could not catch what he was saying, what is meant by that. Anyway, section 70.
71. For the purposes of payment or assessment of tax or any claim to input tax under this act, the burden of proving that any transaction of a dealer is not liable to a tax or any claim to deduction of input tax is correct shall lie on the dealer. It is unqualified. It does not say prima facie, preliminary, shifting.
Straight away. It
Now,
lies on the dealer.
It lies on the dealer. And then it says that if he produces a false document, I can impose penalty, etc. This, my lord, has been interpreted by the Supreme Court in a very interesting expression, my lord. And the Supreme Court gives a very interesting expression, my lord. Your lordships had prior occasion to look at it, but I will place it afresh. Your lordships may come to para 9.1 directly at about page 13 of the printout. I can read the entire judgment, but the gist is in
Paragraph 9.1.
9 ಅಲ್ಲಿ ಅವರು ಇದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ 9.1 ಅಲ್ಲಿ thus the provisions of section 70 quoted herein above in its plain terms clearly stipulate that the burden of proving that the ITC claim is correct lies upon the purchasing dealer claiming such ITC. Burden of proof that the ITC claim is correct is squarely upon the assessee who has failed to discharge the burden. Merely because the dealer claiming such ITC claims that he is a bona fide purchaser is not enough and sufficient. The burden of proving the correctness of ITC remains upon the dealer.
Will not get shifted.
Does not get shifted. Then there is harsher or harder, tougher words that are used. Mere production of invoices or the payment made by checks is not enough and cannot be said to be discharging the burden of proof cast under section 70 of the KVAT Act 2003.
Very same provision. In this act also.
Yeah, it is the same. It goes from this act. The dealer claiming ITC has to prove beyond doubt.
As if in criminal case.
Respectfully, I may not be right. Criminal cases uses beyond reasonable doubt.
Here, not even reasonable.
Beyond any doubt.
Whether the absence of word reasonable is only very incidental.
I was unable to find.
But beyond reasonable doubt was till 18th century. It was not beyond reasonable doubt. It was beyond doubt.
Beyond doubt.
Thereafter, the reasonableness came in. A.P. Herbert, in his Uncommon Law, has discussed these things. Very humorous writer he was. He, instead of common law, he wrote Uncommon Law and very bitterly criticized judgments of the English judges and called the Lord Chancellor to write the foreword to the book. Then the Lord Chancellor said, he has brought me to write the foreword so that he can preempt the contempt action.
The dealer claiming ITC has to prove beyond doubt that the actual transaction, which can be proved by furnishing the name and address of dealers or the selling dealer, details of the vehicle which has delivered the goods, payment of freight charges, acknowledgement of having taken delivery of goods, which your lordship saw is missing over here. Tax invoices and payment particulars, etc. The aforesaid information would be in addition to tax invoices, particulars of payment. In fact, if dealer claims input tax credit on purchases, such dealer purchaser shall have to prove and establish the actual physical movement of goods, genuineness of transactions by furnishing the details referred above, and mere production of tax invoices would not be sufficient to claim ITC. In fact, the genuineness of the transaction has to be proved, as the burden to prove the genuineness of transaction as per section 70 of the KVAT Act would be upon the purchasing dealer. At the cost of repetition, it is observed and held that mere production of the invoices and or payment by check is not sufficient. So therefore, my lord,
this judgment runs counter to the spirit of this observation.
The spirit and letter, my lord.
That also.
Spirit and letter. For I could have understood, my lord, if the tribunal, after having gone through the record, since this court is exercising extraordinary revisional powers, I could have understand that the tribunal has gone through all the records and said, look, I am satisfied beyond doubt.
Can't say that.
And the assessing officer or the first appellate authority was acting unreasonable in terms of Wednesbury.
Yes, the tribunal may not be right in saying the burden is shifted.
Tribunal says, now it is for you to meet it. That, my lord, on the question of law, this order has to go, my lord. And if this goes, my first appellate authority is revived, my lord. This is the only.
Sorry. Appeal allowed on the following grounds. Number one, the very approach of the tribunal runs counter to the observations of Apex Court at para 9.1 of is reported judgment only. The other
reported judgment is there. I will produce the report also. I'll give it to the court of substance. It's reported.
In the state of Karnataka versus Messrs. Ecom Gill Coffee Trading Private Limited. Private Limited. First stop. Hello.
I'm deeply obliged.
Regions to follow. Now we have 5 days to furnish regions for our orders. Apex Court has given 5 days to us now.
This is a constitutional court with plenary powers, my lord. I don't know.
Yes.
Number 39.
My lords, only request. I just came back last night, my lords. I have some more.
Next week,
some matters have gone to next week after next.
Call week after next.
Time for the appellant here.
Let him come after, week after next.
I had spoken to Mr. Tirumalesh.
Very.
42, government advocate.
Same, my lords.
Same.
42, 43 aurdu. We can.
42, 42, 43. 43 also you need time?
Please, my lord.
Well.
Up to 46 if your lordship.
46.
Up to 46 your lordship is obliged.
Yes.
I have informed Mr. Arbati also in 45.
Just inform them.
I have informed.
They need not wait in our.
I have informed Mr. Arbati also.
47, Aditya D.
Yes.
Deeply.
Aditya.
Lord, appear for the petitioner.
But
Lord, this is a case where the petitioner has challenged the cognizance taken by the land grabbing tribunal against the petitioners, my lord. My lord, the short facts of the case is that, my lord, the petitioners the father of the petitioner was a my lord, copy is served. They thought, my lord, order sheet may be perused, my lord. Since
will you not give one more copy?
My lord, I'll
Petitioner
give,
is directed to furnish full set of papers again on the learned AGA.
my lord, my humble request is
Call this matter.
the last date of hearing the order note Swami.
Objections
Objections file ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ objections will be forthwith ಅಂತ order ಆಗಿದೆ ಸ್ವಾಮಿ. Every occasion they have been seeking for copy.
ನಿಮ್ ದುಡ್ಡಲ್ಲಿ ಮಾಡ್ಸ್ಕೊಂಬಿಡಿ.
ಅಲ್ಲ,
ನೋಡಿ.
my lord, I'll furnish the copy. I'm praying for an interim order, my lord.
Interim order ಕೊಡೋಣ. Interim order ಕೊಡೋಣ.
Please, my lord, that's only my suggestion.
ಬಟ್ ಕಾಪಿ ಕೊಡ್ಬೇಕು.
ಕೊಡ್ತೇನೆ ಸ್ವಾಮಿ. ಎಸ್ ಸರ್, 3 ಸತಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ objections ಫೈಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಫೈನಲಿ forthwith ಅಂತ.
Proceedings before the special court shall not be precipitated till next date of hearing.
Please
call this matter week after next. First petitioner to serve one more set of petition copies. Petition. One set of petition copies and documents on the learned AGA Srimati signs right now. Order shall be released. Order shall not be released till service is done. Next. ಸಣ್ಣದಕ್ಕೆ ಜಗಳ ಆಡ್ಬಾರ್ದು. ಸ್ವಲ್ಪ otherwise ಇನ್ನ ಕಡೆ 10 ಕಡೆ we form opinion.
No,
very opinionative. Judges are very opinionative, I tell you. ಅದು affect ಆಗ್ತದೆ.
That was not my intent, my lord. Petitioner is put to harassment Swami.
ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಗ್ತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ
order sheet I just wanted to
you have said that. You have said that. But be magnanimous. You may earn interim orders in other matters also. Otherwise, you may lose. That should not happen.
My apologies.
Apology ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. ಏನೋ ಒಂದು ಪಾಪ ತೊಂದರೆ ಇರ್ತದೆ. ಒಂದ್ಸರಿ ಮಿಸ್ ಆಗ್ತದೆ. 2 ಸರಿ 3 ಸರಿ ಕೂಡ ಪ್ರಸಂಗ ಬರ್ತದೆ. ಅವಾಗ ನಾವು ಅಷ್ಟು ಲೆಕ್ಕ ಮಾಡೋಣ. ಸರಿ, DL and Rao ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು. Mr. DL and Rao said, I was appearing for central government. he had earlier counsel term was over. And then at another counsel came and DLN Rao asked, he asked for a copy and DLN Rao gave one copy. Then another counsel came. He gave one more copy. All this was recorded in the order sheet. Then I became yes. I told DLN Rao, sir, I need one more. You need one more copy? We'll give you 2 copies. That should be the magnanimity. ಚಿಕ್ಕ ವಿಷಯ ಇದು ಅಲ್ಲೆಲ್ಲ ಬಹಳ ಆದ್ರೆ ಏನಾಗ್ತದೆ ನಾವು ಊಟ ಮಾಡುವಾಗ ಇಂಥ ಲಾಯರ್ ಬಂದಿದ್ರು ನಾವ್ ಹಿಂಗ್ ಹೇಳಿದ್ವಿ ಇವ್ರು ಹಿಂಗ್ ಹೇಳಿದ್ರು ಹಿಂಗೆಲ್ಲ ಮಾತಾಡ್ತಾರಪ್ಪ ಅಂತ ನಾವು ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ನಿಮ್ ಬಗ್ಗೆ ದೇ ಫಾರ್ಮ್ ಬ್ಯಾಡ್ ಒಪಿನಿಯನ್. ಓ ಇಸ್ ಇಟ್ ಅಂತಾರ ಅವ್ರು. ಈಸ್ ಇಟ್ ಅಂದ್ರೆ ಏನಾಗತ್ತೆ ಹೇಳಿ? ಹಿಂಗೆಲ್ಲ ಮಾಡ್ಬಾರ್ದು. ಬಿ ಮ್ಯಾಗ್ನಾನಿಮಸ್. I will not tell my colleagues that you said like this, etc. But sometimes ಈ ವಿಡಿಯೋ ಎಲ್ಲ ಕಡೆ ಅಡ್ಡಾಡ್ತಾವ ಇವು ಅದಕ್ಕೆ. Okay. ಕೊಡಿ ಪಾಸ್.
Number 19, 10.30. I filed an application for extension, my lord.
ಏನು?
I supposed to complete the order. I wanted to deposit 50% of the amount, my lord. Now I am having a DD. With 2 days, I'll comply the order, my lord.
DD ಇದೆ ಅಂತ ಕೈಯಲ್ಲಿ ಅಷ್ಟ ಅಮೌಂಟ್ ಬಂದ್ರೆ ಅಷ್ಟರೇ ಬರ್ಲಿಕ್ಕೆ.
IA ಕಾಪಿನ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. IA ಕಾಪಿನ.
One more copy. ಕಾಫಿ ಯಾವ್ದಕ್ಕೂ ಇಲ್ಲ ಅನ್ಬಾರ್ದು. ಆಲ್ ರೈಟ್ ಚಲೋ ಅಂತ ಕಮ್ ಅಂದೆ. DD ಎಷ್ಟದ್ದು?
1,41 lakhs. Full amount is there, my lord.
ಅದು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಪ್ರಕಾರನ?
Interim order ಪ್ರಕಾರ.
ಡಿಲೇ ಆಗಿದೆ ಏನೋ?
ಡಿಲೇ ಆಗಿದೆ ಸ್ವಾಮಿ. And direction may be issued to DRAT Chennai to accept this DD and reopen the case, my lord.
ಯಾರಿಗೆ DD ಕೊಡ್ಬೇಕು ಅವರು?
DRAT Chennaiಗೆ, my lord.
Learned counsel appearing for the petitioner borrower draws our attention to our order dated 21/11/2024, which reads as under. Next paragraph. Learned counsel, Niva?
Lord, I am
senior advocate appearing for the borrower submits that waives 2 bank drafts totally for a sum of rupees 1 crore 41 lakh, telling us that this bank instrument shall be submitted to the DRAT at Chennai, which may be asked to accept the tender. First, learned counsel appearing for the bank, though initially opposed the same, now agrees with this proposal without prejudice to in matter of ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತದನ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಾಗ್ತದೆ.
ಹೌದು ಅಲ್ಲೇ
ಅಮೌಂಟ್ ಬರ್ಲಿದಲ್ಲ ಹೋಗ್ಲಿ ಅಷ್ಟು ಅಮೌಂಟ್ ಆದ್ರೂ ಸಿಗ್ತದೆ. Agrees with this proposal on the request of this court, on the suggestion of this court.
Lord, the DRAT will have to be directed to reopen the case.
Recall ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅನ್ನೋದನ್ನ. Next paragraph. Learned senior advocate is also right in telling that although the right of appeal is conditioned on making pre-deposit, sometimes borrowers face some financial difficulty, and therefore such condition should be a bit leniently viewed in the sense that time may be given to make the payment, make the pre-deposit. First up, in the special circumstances of this case, we agree with this proposal. First up, in the above circumstances, this petition is allowed. Semicolon, the impugned order of the DRAT Chennai is set aside. Semicolon. As a consequence, the appeal of the petitioner stands revived to the board, subject to ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇವರು? ಒಬ್ಬರೇ?
Yes, only one.
He depositing a sum of rupees 1 crore 41 lakh lakh within 10 days. ಯಾಕಂದ್ರೆ order ಎಲ್ಲ issue ಆಗಿ ಆಗಬೇಕಲ್ಲ. Please, within 10 days. Within 10 days, with the registry of the DR80. DR80. First, appeal to be heard and disposed of. Full stop. All contentions are kept open. Great. ಆಗಬೇಕು ಸರಿ ಏನೋ ಡಿಫಿಕಲ್ಟಿ ಇರುತ್ತೆ ಅದು ಬ್ರಾಟ್ DD ಆಲ್ಸೋ. ಇವತ್ತು 1,40,00,000 at least ಬಂದ್ರೆ ಅಷ್ಟರ ಇಲ್ಲಪ್ಪ ಅದು ಬರಲ್ಲ.
Can I take back the demand drafts?
ಕೊಡಿ ಅವರಿಗೆ ಡಿಮ್ಯಾಂಡ್ ಡ್ರಾಫ್ಟ್ ಕೊಟ್ಬಿಡಿ. ಡಿಸ್ಪೋರ್ಡ್ ಕಾಸ್ಟ್ ಮೇಡ್ ಈಸಿ. ಓಕೆ.
Timber, password matter, Timber 20. 14% Ashok Kriplani.
My lord.
For amend.
My lord. I've sought small amendment to this amendment. Seek ಮಾಡಿರ ಏನದು amendment?
I filed that, small amendment because actually I have sought the stay, but I have not implemented the party.
ಏನಿದು? What is this matter about?
This matter is about actually my CIRP caste. I was handling one CIRP before the Honorable NCLT Bangalore bench. And my CIRP caste is not being paid. And when the Supreme Court, Honorable Supreme Court directed the Honorable NCLAT to go through my allegations and finalize, and it was not finalized, and even the order was not followed of the Honorable Supreme Court. So on these lines, this writ petition has been filed.
This Dreams Infra India Limited.
Dreams Infra India Limited.
I was their advocate.
Yes, yes.
Therefore, let it go before some other bench.
Before another bench.
Another bench. One of the members of this bench, Bracketnal KSDJ, being disabled, registry to post this matter before other bench after obtaining necessary orders at the hands of Honorable the Chief Justice.
Can be the next date be given?
No. This to be done at the earliest. All.
Thank you, my lord.
All.
Password matter, Timber 24. K.R. Krishnamurthy.
Krishnamurthy. ಏನಿದೆ?
The arbitration dispute. As your lordship aware, under 23, 6 months, within 6 months, the pleadings has to be completed. The respondent.
Identical matter, no, sir.
Identical matter. On the subsequent date, I have got the number I have furnished. 34,942 of 24.
Notice ಆಗಿಲ್ವಾ?
ಆಗಿದೆ. ಇದರಲ್ಲಿ ಆಗಿಲ್ಲ.
Issue emergent notice, interim order as prayed for. First up, call this matter. This interim order is granted since similar relief has been accorded by this court in WP number
34,942 of 24.
On date not correct.
I am sorry.
Call this matter along with the said WP.
I may be permitted to take notice to the advocates also who is appearing before.
In addition to taking usual steps, petitioner is permitted to serve a copy of the petition on the learned advocate appearing for the respondent hearing before the arbitrator.
So that it was.
Whose tenure has expired. I'll call along with ಮಾಡಿರ್ತಾನೆ. ಹಾಗೆ ಹೋಯ್ತು. ಕಳಿಸಿ ಯಾವ ಮ್ಯಾಟ್ರಸ್ ಮಾಡಬೇಕು.
Interim ಮಾಡಿ extend ಆಗಿದೆ.
44 ಅನಿಸ್ತದೆ, ಸೊ ಲೇಟ್ ಆಗಿ ಬರೋದು.
44 ಏನಾಯ್ತಾರೆ?
ಹಾ ಏನಾಗಿದೆ?
Week after next.
Thank you.
ಬೆಳಿಗ್ಗೆ ಇದೆ. ಮಧ್ಯಾಹ್ನ ಇದೆ.
ಸರ್ ಒಂದು ಕಾಲ ಬರ್ತಾರಾ?
ಒಂದು ಕಾಲ್. ಮುಂಚೆನೆ ಬರೋಣ, ಇಬ್ರು ಇದ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ನಾನು ಇದ್ರೆ ಕರ್ಸ್ಬಿಡ್ತಾ ಇದ್ದೆ. ಅವ್ ಇಲ್ಲ ಇದ್ರು ಸಿಕ್ಕಿದ್ರು 2 ಸತಿ.
ಇಬ್ರು ಕರ್ಬಿಡ್ತೀನಿ.
ಹೌದಾ?
ಹಾ
ಸರಿ.
ನೋಡೋಣ. ಅದು EP ರೆಡಿ ಇದೆಯಾ? ಈಗಲೇ ಬಂದ್ರೆ ಈಗಲೇ ಕರ್ಬೋದು. ಹೌದಾ? ಅದೇನ್ ಮಾಡಿದ್ರಿ? ಆದಿತ್ಯ ವಿಕ್ರಮ್ ಭಟ್ಟ ಏನದ? 37 ಏನಾಯ್ತ್ರಿ? ಅಲ್ಲಿ ಇದೆಯಾ ಬಿಡಿ, ಅದು ನೋಡ. 39 ಹೇಳಿ. ಯಾಕೆ ಟೈಮ್ ತಗೊಂಡ್ರೆ ತಿರುಮಲ ಶಿವರಲ್ಲಿ? ಅಯ್ಯೋ
ಆಯ್ತು. ಇನ್ನೊಂದು ಯಾವ ಡಿಸ್ಪೋಸಲ್?
42 ಇಂದ 46 ಎಲ್ಲ ಅವರೇ ತಗೊಂಡ್ರು ಟೈಮ್.
47. ಸರ್